Morning. So we're going to be speaking this morning about managing contracts with a view to avoiding and resolving disputes. So if you manage your contracts well, hopefully you won't get into disputes or find yourself having to resolve this. So just to kick off then, I'm Ali Richards. I'm a partner in our commercial IT and outsourcing team at Gowling, and I deal mostly with public sector, so local and government level contracts. Susanna, would you like to introduce yourself?
Hi there. Good morning, everyone. I am Susanna Fink. I'm a legal director in the commercial litigation team, and I have a specialism in acting on procurement challenges, both for public sector defendants and also for claimants.
Thank you. So in terms of the agenda this morning, we're going to speak a little bit about some of the lessons learned from public procurement. We're all in the public sector here today, and most of the contracts, unless they're perhaps low value or there's been a direct award, will have been subject in some form to public procurement. So there's a lot to be learnt from that. We'll look at preventing disputes rather than having to cure them down the line, and some of the key mechanisms in your contract. And then Susanna will go on and look at some of the remedies, and look in particular at arbitration or litigation, which is the best and why. She'll talk a bit about negotiation, mediation, and also give us some key tips on managing a dispute. So I'll just start by mentioning the an NAO report. So back in July, the National Audit Office issued a report on competition in public procurement, and looking at some of the lessons learned. And it examined whether government has mechanisms in place to properly understand and encourage competition in public procurement, and how government departments can make use of their competition in a more effective way. So my focus is very much on managing contracts this morning rather than the procurement side, but the report did highlight some really useful points relating to the ongoing management of contracts. Ultimately, how contracts are managed during their term and lessons learned will play heavily into your re-procurement when you get there, and the development of new contracts or thinking about going out to the market. So there's key highlights in the report. There's 6 in total. I'm going to touch on just 4 of those before going on to consider some of the key contract issues. And if they're not things that your organisation already does, I'd really recommend firstly reading at least the summary of the report. It's quite a beast of a document, but also consider how those recommendations ought to be factored into your routine contract management tools. If there's an incumbent contract, there's clear benefits to regularly having dialogue with them and sharing an understanding as to the risks to your organisation, but also from your point of view, understanding the risks for the supplier, and jointly considering the steps when problems occur is actually one of the best tools you've got in your armoury, not only as in terms of supplier performance issues, but risk of failure is a risk to your organisation in terms of delay, in terms of costs escalating, and being able to understand what's underpinning those issues at an early stage helps you with managing your contracts, but also with managing future and avoiding disputes and helping with future procurement activity. One of the things the report talks about is engaging with suppliers, and in doing that you should collect detailed information about the market whenever possible, including from existing suppliers, understanding collective buying arrangements can, and how that can be used to strengthen your purchasing power, and engaging with suppliers to understand what the capabilities, what the different circumstances that that will impact delivering services. And most, or at least a significant percentage of your contracts will be based on model terms, whether they're Cabinet Office CCS contracts or one of the other model forms, and they'll already have transparency requirements in them that require your suppliers to provide various contract data and reports. They'll also have requirements around continuous improvement, and they'll be measured in a number of ways. But the report talks about there being a lack of realistic requirements being required as part of your procurement. And that can lead to lack of bids or the appointment of unsuitable suppliers. And at worst, you end up with a contract that actually is not reflecting what you actually wanted to, the outcomes from that contract to be. And of course, where that leads you is to a perception that the contract's being poorly performed, rather than an appreciation that actually maybe you've not quite got it right at the outset. Increasingly, we're seeing contracts being drafted in a more permissive approach, where KPIs and incentives around collaboration support good performance, and there's certainly some things to look at or consider around that. So the next lesson learned they talk about is when managing a contract or market, authorities should ensure that there is an appropriate mobilisation period to allow relationships and the contract processes to bed in. And very much something that we see is quite often the mobilisation's planned to the nth degree, but there's sometimes not enough flexibility for the mobilisation in terms of the actual award of the contract. Quite often you've got indicative timescales for awarding your contract, but there may have been some delay due to procurement assurance exercises, or a delay because aggrieved bidders have raised questions, or clarification questions have taken longer. So ensuring there's enough flexibility for your mobilisation and planning contingency for any delays to contract award should help helps your suppliers manage the risk, but also the organisation. And consider other enablers in the contract, such as subcontractors in your supply chain, or commitments that your buyer may need to consider. So the knock-on impact of any delays on your mobilisation period. Fully understanding those risks from both perspectives can only be a good thing, and ensure you collect appropriate data to assess the outcomes achieved and as well as those desired. The next thing that the report considers is some of the things to think about before the end of the contract, using the mechanisms in the contract to collect data on the supplier health and the market to inform future procedures. So that's in terms of your incumbent contract, but also what the market generally is doing, and having that knowledge not just immediately before the end of the contract, but leading up, even like 6 months, even longer, depending on what you're procuring, can often be helpful. Ensuring that you've got full visibility and the market understands the visibility in terms of costs or information that will be needed to support transition from your incumbent to potentially a new supplier, and maintaining contingency plans in case that there is supplier failure. So that might not be at the anticipated end date, it could be much earlier than that. So making sure that your contingencies in your contract allow for early termination as well as expiry will be helpful. The other points that we'd note about your in-life contract is ensuring that you're managing your contract to reflect the mechanisms you've got, and if the contract mechanisms aren't working for some reason, so if your KPIs don't quite work or things have changed, there is a danger that your contract becomes meaningless in some way, or that the costs may become unpredictable or unmanageable, or worse, the relationship can start to sort of crumble between yourself and your supplier. So making sure that trust continues through the contract by using the mechanisms and making and continuing to ensure your contract mechanisms are relevant, and support both the supplier and the authority in managing your contract and managing risk around that contract, is the best thing. If they don't work, do consider using the change control procedure. Yeah, and then just in terms of what my other thoughts around that is really think about what sort of relationship you want with your suppliers. So quite often we see organisations going out to procure on the basis of wanting collaboration or a partnering arrangement, but when you look at the contract mechanisms and the way a contract is later managed, it's very much actually master and servant, and you're looking for suppliers to deliver on time to quite high performance measures. And actually it would have been clearer from the outset that it was reflected that you wanted a master and servant type relationship and not hiding behind something that says it's collaboration but it isn't really. So I do think be really clear from the outset as to what you're expecting, and reflect those behaviours in the way that you manage your contract. So whichever approach is adopted, and none are wrong, consistency I think is the most important thing. The inconsistent approach is more likely to lead to mistrust or a broken relationship. So I'll go on just to think about some of the what your contract looks like. Some of those probably sounding obvious things, but things to think about in managing your contract to avoid a dispute. So in terms of some of the obvious basics, and I say them because we see them on a daily basis happening, make sure you've got a written contract. Now, it's quite, for most of the contracts that you, as a contract team you'll be involved in on the procurement side, will be high value, so they'll be subject to some form of procurement. But don't forget the lower value contracts, or if there's been an emergency and you've had a spot purchase, make sure you've got a written contract. Make sure it's clear to both sides the basis on which you're contracting with that parties, and leading on from that is make sure that you know who the entity is that you're contracting with, because quite often you'll be dealing with a group of companies. Use company numbers, make sure that you've recorded who those parties are, and we do recommend having a PDF or a final version of the contract signed by all the parties, whether that's a full-blown model services contract or an order form, something that's really clear what that final agreed form is and it's signed. And then if you need to change, we've been talking about potential changes to your contract to keep it meaningful, make sure that you keep an updated version or a contemporaneous version showing where those changes have been made, so it's really clear to those contract managers. And final point there is deal with expired contracts. We're quite often asked to look at contracts which the term expired some time ago and they're in effect sort of holding over. That's not only a procurement risk, but it's also could lead to arguments that there's a different perception as to what the contract terms are. So really make sure that they're considered, and avoid uncertainty as far as you possibly can. I think the other thing to say, if relationships do break down, if there is some dispute, there's quite often a starkly differing view as to what was originally agreed, and it's quite difficult to reconstruct that position based on emails or notes of or memory as to what happened, and you end up litigating as to what actually the contract is rather than having something something firm. So just a few thoughts on termination. So ending a contract can be quite painful if you've got a dispute, and sometimes ending a contract quickly can be cheaper than dealing with that dispute. So making sure that your contract is very clear as to the circumstances in which your contract can be ended is really important, and that includes whether you're only allowed to terminate a contract if there's been a default, and if there's one of the parties has been given a chance to remedy that default before you can invoke that, or do you have a right to terminate because at will without any reason? So being very clear about what those options are is really important. Also important is being mindful of what the timescales for using any of those termination mechanisms is important. So if you've got 3 months, you've still got to pay, continue to pay your provider for that period, and also be very clear about any other schedule or terms you've got in your contract that deal with compensation or other payments that might arise on termination in terms of subcontracts or licenses, for example. All of those factors will play into any decision you may be taking around whether to deal with an issue as a dispute rather than invoking other rights you've got. That final bullet point there, we mentioned avoiding having a perpetual contract. So you quite often see contracts being entered into where it's a rolling term. They can have long notice periods, and we have seen some that say you can only terminate on a given date in the year. And of course you're then sort of stuck in, and it automatically renews unless you give notice within a certain time scale. So do be aware of those. Likewise, so having a long-term contract with a very long term might be really helpful to suppliers in terms of them being able to give you a better pricing, but of course with that it could bring sort of higher risk for an authority in terms of the cost of change, price increased, that your specification may change. We see some sort of long sort of IT or construction type contracts which might run for sort of 8 years plus, and of course things do change, circumstances that are impacting the UK right now in terms of infrastructure, in terms of fuel costs. That can be higher risk in terms of managing on the long term, and is that longer term worth the risk of having reduced costs? So you might want to consider having a break clause, even if you have to pay a fee or an amount to break the contract, or some form of break payment. And also always consider what happens, as I say, whether there are particular consequences when they'd fall due, and what that covers. In our experience, what leads to termination or disputes are most often linked to one of these things, so price, performance, or delay issues. I think clarity as to the expectations is probably top of the tree in terms of ensuring that your the circumstances linked to poor performance, delay issues, and making sure they're absolutely clear in your contract is the best thing you can possibly do. As I've said previously, whatever your contract says in terms of managing that, be seen to be managing your contract in the way you envisaged at the outset. And if that's not working, amend it, because as soon as you start managing in a slightly different way, you are likely to create ambiguity, uncertainty, and mistrust. So as part of that, as I said, you know, if there's a need for change, use it in an appropriate way, and of course mindful of procurement regulations in terms of the extent to which you might change, but it's often a great way to preserve a contract that may not be quite going where you anticipated it was, but in view of risks for both supplier and the authority, it's definitely worth a thought as to whether there's a more sensible or pragmatic way of managing performance or a delay issue or pricing by looking at whether you're able to change the contract in a mutually acceptable way. And performance management, that, I mean, all of this is that point that if you've got a mechanism that says that you're going to manage in a certain way, including the way you're going to govern your contract and manage service levels, follow what you said you're going to do, and that will give you the best or preserve the relationship as far as you possibly can with your contractors. So Susanna's going to obviously come on to some of the disputes mechanisms in a bit more detail. Before you get to dispute, some of the mechanisms or the tools in your contract management toolbox will be around asking your suppliers to rectify delays or performance issues. And there's usually an obligation on the supplier to continue to provide the services, but there may be consequential impacts as well on performance financials, which can be overlooked. So be really careful not to overlook issues that could then themselves also become subject of a separate contract dispute. So if you say that you're going to have service credits, invoke them. If you're even considering not imposing service credits for whatever reason, make sure that you're not in some way creating a new contract mechanism or you're waiving your rights. So document, if you're offering some sort of grace period, then make sure it's documented and managed. Likewise, if there's delay payments, be really clear on what those delay payments are, how long they run for, and I'd go as far as saying record when they're invoked and what the accruing amount is, and then again record when they stop. Again, even if for whatever reason you may decide to give your contractors a break from any of those delay payments, again record it, but be clear you're not waiving any rights you might have under the contract. And the last point there is about liability. Quite often in your contracts there will be liability caps or sort of super caps, so that if you've used any of the mechanisms to impose delay payment service credits, be clear as to whether they are subject to one of those caps. So the caps sometimes operate on an annual basis, but could be a lifetime cap, and just be clear that or be aware that that cap hasn't been reached, and it's going to in effect risk you not being able to enforce future rights if that cap is reached. So to just be careful about that, and certainly one thing to think about when you're drafting new contracts to go out to the market. So these are the things. So in you'll wish you had a clear liability clause. So again, what are those caps? How do they apply? When do they apply? Over what period? Be clear about force majeure. So are there any circumstances in which your suppliers may be performing badly, but there's been an event that should give them some relief from performance for a period of time, but also having that clarity about what the consequences are and what that relief looks like. And yeah, if it's so, does it apply to the circumstances? Does it fall within that exclusion category? And what are the consequences? Being really clear on those. Yeah, having really clear notice. So if you've got, if there's a notice for rectification, for example, be really clear on what those notice periods are and on who those notices need to be served. Yeah, we've spoken a bit about disputes clause and escalation, and then of course there's a raft of other clauses such as third parties. How are they impacted? Are there any rights for your subcontractors? Do you have rights to vary particular performance mechanisms if they're not working, or you need something that is more practical? And we've spoken about not waiving rights. The other point to mention is your law jurisdiction clause. Be very clear if you've got a clause in your contract that says where your contracts may be enforced. Is there anything limiting your rights? I think Susanna will probably say a little bit more about the courts versus mediators, whether there's anything that restricts you from doing one thing over the other. And also, is there a country or a jurisdiction in which you've got to enforce those rights to? So practically, so know your contract, really understand your contract, what's in it. And if the contract isn't working, if you're finding yourself managing a contract that's quite different from what is practically happening on the ground, that'll be for one of two reasons. One, because the team that you work with don't really understand the contract that was signed, or they've ignored it, or it's just not working. So think about making sure your contract is working for you. As part of that, maintain the meetings, maintain the governance and the arrangements that you've said that you will. That your suppliers are way more likely to sit up if they can see you're enforcing your rights under the contract. You take it seriously, and they should behave in and mirror that behaviour in the same way. Maintain risk registers. We said at the outset about ensuring that the supplier as well as the authority should be aware of each other's risks, and managing that in a way that is most effective for both parties is quite often a better way of achieving a resolution. Make sure you keep records, so of any action taken, any instances where the contractor has failed to perform, and the steps you've taken to remedy those. If in the unfortunate event that you end up in a dispute, those records will be your most important tool. Yeah, pay invoices properly. So your supplier invests quite a lot of time and money in winning a contract, and again that mutual respect comes from paying them on time, and so that they're also able to pay their subcontractors on time too. So having that trust is equally important. And yeah, don't delay in dealing with any emerging issues or delays. Look out for the warning signs, and the quicker you're able to deal with them and be seen, again, that goes to the heart of being a respected and intelligent contracting authority that's likely to get better respect from your contractors. Thank you. Right, I'll now hand over to Susanna, who will talk about managing disputes and some of her top tips. Thank you.
Thank you very much, Ali. So at the point of preparing your contract, you really need to think then about whether you wish to have litigation or arbitration as your dispute resolution mechanism. There are pros and cons of both methods. So I just thought we'd quickly run through what those are. so that you'd be better placed to make that decision. So some of the advantages of arbitration, a main one is confidentiality. So arbitration hearings are held in private, and there are implied duties of confidentiality in English arbitrations, which prevent the disclosure to third parties of most documents produced or disclosed in an arbitration. So that will include all the statements of case and obviously the arbitration award that is made at the end of that. So if you're an organisation that wants to continue doing business with the party with whom you're in dispute, it might actually be helpful for all the proceedings to be confidential, and then you don't have to wash your dirty linen in public, so to speak. By contrast, litigation obviously is rarely private, as the public can search for information and non-parties can obtain copies of the statements of case, they can obtain copies of judgments, and obviously the decisions are well publicised amongst the legal community. Just one thing to say there with litigation. So in procurement challenges, there is the ability to ensure that commercially sensitive information is redacted from documents that are filed at court. So there tends to be a public version and a redacted version, and quite often there are confidentiality rings in place too. So it might well be that only the lawyers and one representative of each party would see that full unredacted copy. Back to some of the advantages of arbitrations here. Flexibility is a real benefit. So in arbitration, there are very few set rules as to procedure. The parties can agree at the outset the procedure that best suits them, or they can choose to adopt the procedural rules of one of the many arbitral institutions there are out there. Essentially, a party is free to use many innovative ideas to try and tailor the procedure specifically to the dispute at hand, with the result then that the arbitration would proceed more effectively and efficiently. Once an arbitration has started, the parties can also influence the procedure much more than would be possible if you were in litigation. So, for example, in arbitration, the parties are free to choose how to decide how evidence should be adduced, presented, and assessed by the tribunal. Whereas in litigation, there's quite stringent rules as to exactly how you draft a witness statement and what you can and cannot say. Moving on to expertise. So what I mean by this is that the parties in an arbitration can choose their tribunal, and they can specify what qualifications and level of experience the various members should have. So if your dispute would benefit from having somebody with technical or scientific expertise, then you can always specify in your arbitration clause that that is what you want your tribunal to have. You can also ensure that the people who you want to appoint will have adequate time to deal with the dispute by finding out in advance what sort of availability they have. And this again would be an advantage over litigation. Finality of the decision. So in arbitration, the opportunities to appeal or challenge an arbitration award are really quite limited. So when you have an arbitration award made, this does tend to provide more certainty to the parties that it's not going to be challenged in any way, and there is that finality. Generally, this is perceived as an advantage, although I would just caution that there is sometimes a risk that arbitrators won't spend as much time considering the reasons for their decision if they know that it's not going to be scrutinised by a higher court or tribunal. Enforceability. This is really something that only should be a concern to you if the party that you're in dispute with is actually based in a different country. But if that is the case, then the ease of enforcement of an arbitration award is probably one of the most important factors in favour of arbitration. There is the New York Convention, which is an international treaty which provides for the enforcement of international arbitration awards quite easily across the world. And there's no real equivalent for this when it comes to enforcement of court judgments. Now, in terms of the costs, arbitration is often perceived as being cheaper than litigation, and quite often that is the case, but I have to say it's not always. So, for example, if you've chosen to have a three-person arbitration panel, and there is choice there, obviously, when you draft your clause as to whether you go for one arbitrator or three arbitrators. But if you do have three, and you've chosen to have your arbitrators, for example, as some eminent King's Counsel, then you're probably going to end up paying some quite hefty hourly rates for all three members of the panel. And again, this is different to litigation where you're not paying for the judge's time, so to speak. And in arbitration, you also have to pay the administrative costs. So if you've hired a venue in which to hold your arbitration hearings, then you'll again have to pay for that venue, which isn't the case if you were in litigation. As regards speed, again, it is true that arbitration can be a much quicker procedure. If you manage to make those procedural rules to work in your favour, then it can be quite a short timetable from the start of proceedings all the way through to hearing. And it can be, again, quicker as compared to your typical lead timetable to trial in litigation, which can be 18 months to 2 years. But again, if you've opted for a 3-person tribunal and you've chosen members of the tribunal who are very busy, King's Counsel, then again, it might be that it's going to take some time to find a date when everybody's free. And again, this can cause delay and it can take a lot longer. If we can just move on now to the next slide, and I'm going to talk about some of the advantages of litigation. As opposed to arbitration, because litigation is public, then there's a whole body of precedent there, which can assist you if you want to know for sure exactly how a contractual provision is going to be interpreted, or you want to use your litigation as a test case or provide a warning to others, then obviously it is useful to have that body of precedent, and that would be a reason why you might go for litigation rather than arbitration. Similarly, in a way that you have certainty in arbitration, in litigation, you have more appeal rights available. And having an appeal, a right of appeal, does act as insurance against errors of law by the trial judge. So it can be beneficial in that way. But if, on the other hand, you want to have a strict black letter law approach to contractual interpretation, then you very well may be better off having litigation, depending on the other commercial considerations at play. If you're involved in a multi-party dispute, then it's as well to know that in litigation, you obviously have rules as to exactly how you can join other parties to a dispute and how you can consolidate several sets of proceedings. In arbitration, the situation is different. Whereas some of the arbitration rules do allow for consolidation and also for joinder, they will inevitably require all the parties involved to consent to that. And obviously, if you have a third party, they're just not going to consent to being joined to some arbitration proceedings, because why would they? It's not in their interest to do so. So essentially, that means it's really quite difficult in practice to join another party in arbitration. So better off staying in litigation again if that situation arises. The active case management that you have in litigation can be quite beneficial. So again, in arbitration, you often deal with recalcitrant parties, and delays can be caused because they just don't have those tools that can be used to apply pressure on the parties in order to enable them to speed up. Whereas in litigation, there are many tools available. You have default judgment, unless orders, contempt orders, all of which will encourage a party to get on with it. And finally, whereas we talked about the fact that arbitration is private and litigation is public, obviously the fact that litigation is so public can be very much in your favour if you want to, for example, damage the reputation of the other party by publicising the dispute that's going on. That can be quite a useful mechanism. So I'm just going to look now at some other dispute resolution mechanisms. If we can move the slide, thank you. So there's negotiation and without prejudice here. So negotiation is a tool that needs to be thought about, again, at the beginning when you just start having a dispute, but then equally it applies mid-dispute and throughout the course of any proceedings that are commenced. It is a way to resolve those proceedings. So negotiation is an attempt by the parties' representatives, whether in writing or in person, to resolve that dispute in a neutral setting. It can help to preserve an ongoing commercial relationship, and also it can provide a cost-effective route before moving on to more formal dispute resolution mechanisms. Now, the without prejudice rule should apply to any negotiation, and this is essentially intended to encourage settlement discussions without parties weakening their position in the formal dispute. So basically, if this rule applies, then parties can write and speak openly without any fear that what they're saying is going to be then used against them in the proceedings, whether those be litigation or arbitration ones. And this is because those statements that are made in negotiation are generally not going to be admissible, either in the substantive dispute or on any question of costs. If instead your discussions are held on a without prejudice save as to costs basis, then this is different. And this will enable those statements that are made to be considered in costs hearings at the end of the proceedings, specifically for the issue of deciding who's going to be responsible for costs. Now, it's important to note that this without prejudice rule only applies to negotiations which take place in a genuine attempt to settle a dispute. So there will have to be consideration as to whether the parties were acting in good faith in that respect. If you're holding a meeting or a discussion, it's always best to state at the outset that the intention is that you're going to be holding these discussions on a without prejudice basis, so that both parties are aware of what's intended by that. Having said that, if you do forget to make that point, or likewise, if you forget to mark on a letter that it's without prejudice, that's not necessarily fatal to whether those discussions or communications will be considered to be without prejudice at the end of the day. If you're found to have been involved in a genuine attempt to settle, then they will be held to be without prejudice. Likewise, if you mark a communication as without prejudice, that's not going to be conclusive. It'll be helpful to show that that's what was intended, but again, if it wasn't genuinely an attempt to settle, then just by marking a communication without prejudice is not going to help you. If we can move on now to look at mediation. Mediation, again, is something that you can include in your contract as a mechanism, something that should be thought about either before you start litigation or arbitration, or indeed once those proceedings have started. Similarly, if it's not in your contract, again, it's something that should always be borne in mind as an alternative dispute resolution mechanism, whatever stage of the proceedings you're at. Essentially, mediation is a form of alternative dispute resolution where the parties use the help of an independent third party, who's the mediator, and then they facilitate discussions in the hope of resolving the dispute. Although mediations can be evaluative, the role of the mediator is generally to facilitate resolution. So you're not trying to convince the mediator that your case is correct in the way that you would with a judge or a tribunal. Instead, the mediator is simply there to try and encourage the parties to reach a settlement which they're both comfortable with. Mediation is a confidential process, which is important to note. So anything said in that mediation is said on a without prejudice basis. So if that mediation breaks down and you don't eventually reach a settlement, you don't need to worry about any concessions that you have made in the course of that mediation. It's a voluntary process, which means that either party can walk away at any point if they wish to do so. In practice, that's quite rare. I mean, you do sometimes see it in mediation that one of the parties will flounce off in the mid-mediation because they don't feel they're getting anywhere. But as I say, it's relatively rare. And the main point to know now is that mediation must be considered in every case. It's part of the civil procedure rules, and the cost consequences of unreasonably refusing to mediate can be quite severe. The Court of Appeal have specified factors which need to be taken into account when deciding whether a refusal to mediate was unreasonable or not. Some of these are the nature of the dispute, the merits of the case, whether the costs of mediation would be disproportionately high, which is very rarely the case, whether any delay would be involved if you decided to mediate very late in the proceedings, whether mediation has a reasonable prospect of success, and whether the courts have encouraged the use of mediation, which they will have done. And just to say here that when considering what's an unreasonable refusal to mediate, the fact that you thought the parties were too far apart and that actually there was a hostile atmosphere between the parties and it was never going to settle, that's been held not to be a good reason. I mean, that's often the case in all litigation and arbitration. And the idea is that you just have to try and find that compromise position. So how does mediation work? In a typical one, the mediator will invite the parties to submit to a short document which sets out their position in advance of that mediation hearing. On the day of the hearing itself, the parties will initially all meet in one room for a general introduction where the mediator tends to provide an overview of the process, the role and the procedure that each party will have on the day. Each party will then have that opportunity to make an opening statement, which tends to give its perspective on the dispute and highlights its points of particular concern. After the opening, the mediator will then spend time talking to both parties. There'll be quite a lot of shuttling between the rooms. And if need be, it might be that they will bring the parties together again. If you're lucky and the parties do agree on a settlement, then the mediator will, with the help of the parties, draw up a settlement agreement, which the parties will then sign with the idea that that settlement agreement is then going to be contractually binding on the parties. Quite often you see actually that you don't manage to draft a settlement agreement on the day or reach a compromise on the day, but it's very common in the following days or I'd say in the 2 weeks following mediation that a settlement is reached. So what are the advantages of mediation? I would say on average about 80 to 90% of mediations are actually successful. So this is actually a high success rate, and obviously it's something that you really need to bear in mind and it's worth doing. If you do manage to reach an agreement very early on in a dispute, then obviously you'll be saving an awful lot of costs and management time involved in obviously if you'd instead not settled and proceeded to litigation instead. Likewise, mediation is important if it then transpires that your case is actually not as robust as you thought it was, because then obviously you can be aware at an early stage what your exposure might be and probably take more of an effort to try and compromise and reach that settlement agreement going forward. Moving on to the next slide, I just want to talk about a few points to consider if you're proposing a mediation. First one is what will the mediation procedure be? You could defer to the model of a mediation service provider such as CEDA, which is the Centre of Effective Dispute Resolution. Or it may be that the parties choose to adopt a different mediation procedure altogether. It's really quite flexible. How will costs be shared? The mediator's costs need to be paid for. It's usual for parties to agree to split those costs and indeed the cost of the venue if you've hired one. But equally, you don't have to reach that agreement. Sometimes the parties reach that the party who loses overall will be the one that bears the costs. And that's up to you. Where will the mediation be held? It's quite common to hold mediations in one of the parties' offices or in one of their solicitors' offices. On the other hand, you might decide that you want a more neutral venue, in which case there are, obviously rooms that can be hired to do that. But the disadvantage there is you then would be paying for that venue hire, which you probably wouldn't be doing if it was held in a solicitor's office. Who will the mediator be? Both parties should make proposals as to who they suggest should be the mediator. And again, here, it might be helpful to appoint somebody who's got commercial experience, or if, for example, your dispute is about IT, you might want someone with technical experience of IT. But again, it probably tends to be more common that you would appoint a lawyer who can act as a mediator for you. How will you make that decision if parties can't reach agreement as to who it should be? Again, you can specify that if the parties don't reach agreement, that a centre such as CEDA can decide who should the appropriate mediator be. Who will attend the mediation? This very much depends on the strategy that you choose to adopt. You might, for example, want the weight of legal advisors there, and I say probably 9 times out of 10 they will be there. But alternatively, it might be that you decide that having the lawyers there actually wouldn't help the situation, and you just want the commercial parties to be there and try and reach an agreement just with the mediator, and that's fine if that's a decision that's reached. It is helpful to have the decision makers on hand, preferably in person, but if not, on the end of a phone, because again, if you're going to try and do a deal on the day, you want those stakeholders around and available. And if insurers are involved, for example, then you'll want the insurers available at the end of a phone to help. How long do you want to give for mediation? You might specify a time such as 10 till 6. But again, if it looks like a mediation is going to be successful and the parties are making good progress, it is not at all uncommon for mediations to go on into the small hours. Alternatively, as I've said, sometimes people walk out. So it very much depends how things progress. Should the mediation be facilitative or should it be evaluative? Is the mediator there to facilitate the parties' own attempts to reach settlement, or alternatively, are they there to evaluate the merits of the case and provide a written recommendation? Because you can request that if you prefer it. And in that case, you need to consider whether you would want that recommendation to be binding or not. I mean, maybe it wouldn't suit you for it to be binding. So that's mediation. Moving on now to some steps that I wanted to talk about that it is worth you considering if you're managing a dispute. And these are probably more likely to apply in the early stages before you decide to enter into any lengthy and expensive court battles. Firstly, it's vital that you take the time available to undertake a thorough fact-finding mission, so you can be sure that you do actually understand the situation fully. For example, has there already been a breach of contract, or has one just been threatened? And if a breach has already occurred, then how serious is it? And have you actually taken the time to consider both your and the other side's obligation and liabilities, as well as any consequences that might follow from any steps that you choose to take? All of this needs to be clear before you take any actions. I would also recommend taking legal advice, as this will clearly be necessary if you're looking to establish the merits of your own position. If you undertake that legal analysis, it's going to help establish the extent of any dispute and provide some sort of independent view on who might be to blame for the breakdown in the relationship, and more importantly, how you can look about trying to resolve that dispute amicably. If you have an internal legal function, then by all means, those in-house lawyers can help you in those early stages. But equally, it might be that there's value in instructing external advisors. Dealing with disputes can obviously be very time-consuming, and it might assist management and in-house legal if you have some external support from lawyers, which then would prove helpful and cost-effective in the long term, as well as adding a further layer of impartiality. It's really important to try and remain calm, although I appreciate that is often easier said than done in many situations. But it's worth knowing that the reason why disputes can escalate quite unnecessarily is because people think a personal attack is being made on them when actually that's not the case at all. It's important to try and distance yourself from any emotion and try and remain calm and objective if you can. Don't act out of frustration and say things in the heat of the moment. So, for example, terminating the contract before you've actually thought through the implications of that, or accusing the other party of being in breach when the reality is there isn't. Essentially just being careful not to say something that might backfire on you long term. As Ali mentioned earlier, communication channels with the other side should be kept open. It's always important to listen to the other side's views so that you can fully understand exactly what the other side's issues are and what the concerns are, and what might motivate all parties to step back from that brink of litigation. Try and keep an open mind about compromise. I'm conscious that some people simply are not in that sort of mood at the beginning, especially if they think they're in the right. But obviously, in order for any deal to be done, and it's always worth doing a deal just so as to save those legal costs and also management time, then you are going to have to be in the mood to compromise. Some of the points that you need to think about when managing a dispute are limitation. So the limitation period is the time within which a legal claim must be brought. And this is obviously vital to be aware of, both as soon as that dispute has arisen and also sort of further down the line just before you're about to commence proceedings. Because if you miss that limitation deadline, it's then going to mean that you're unable to succeed in a claim, even if actually your prospects of success might have been otherwise quite strong. In England and Wales, the primary statutory limitation period is for claims arising from a breach of contract is 6 years from the date of breach. That's if you have an ordinary contract. If you have a deed, then it's going to be somewhat longer than that, 12 years. Some contracts may actually specify within them that there's a contractual timescale within which any claim must be brought. If that's the case, you need to comply with that. and that might be less than 6 years normally provided for. Just to mention here procurement challenges, because these are different again, and these are a type of dispute that will actually have a very short limitation period. So if your litigation is subject to the Public Contracts Regulations 2015 or the Defence and Security Public Contract Regulations, for example, then your claim must be brought within 30 days from the date that the economic operator first knew or ought to have known that grounds for proceedings had arisen. So it's therefore even more critical in these types of challenges that you have to keep your eye on when that 30-day expires and make sure you take actions and plan your strategy accordingly. Moving on now to pre-action protocols. So these are a set of guidelines in the civil procedure rules that must be followed in the early stages when a dispute has arisen, but before any proceedings have commenced. So before taking that final decision to commence proceedings, do make sure that you have followed whatever is in those pre-action protocols, because if not, you may face an adverse costs order against you made by the court. Broadly speaking, the objective of these pre-active protocols is to encourage the exchange of early and full information about a prospective claim so that both parties are aware exactly what the issues in dispute are, with the idea being that it will enable the parties to avoid litigation by reaching an early settlement. And also, if litigation can't be avoided, then it will enable efficient management of proceedings. So in procurement challenges, again, the requirement is that a letter of claim is sent before proceedings are issued. Although due to that very, very condensed timescale that I just mentioned, unfortunately, it is the case sometimes that the letter of claim will be issued probably at the same time as a claim form being issued, or perhaps even the day after. But essentially, I mean, the idea is that both parties will have had time to rehearse all the issues in dispute and respond so that everybody is aware what those issues are. And another significant factor which we do recommend thinking about when a dispute arises is the preservation of evidence. Again, this is a requirement of the civil procedure rules, and should proceedings subsequently be issued, then the parties will be expected to outline the steps that they took to ensure that all paper documents and electronic data was preserved. So if your organisation has policies which results in the routine destruction of data, for example, if an employee leaves the organisation, or alternatively, there is some document destruction policy, then it's very important to make sure that all of those are suspended. It's going to be vital to preserve the evidence that you need to show exactly what happened in the course of that dispute. Likewise, if the parties have relevant text messages or WhatsApp messages on their mobile phone devices, then these also should be maintained and not deleted, because that can be evidence of what happened. It's also a sensible idea to ensure that all relevant papers are located quite early on, as soon as a dispute arises. So, for example, you need to find a copy of the contract in question and all its schedules, if they might be lying around the place, and any variations that might have been agreed to that contract. If it's a procurement challenge, you need to ensure that you have quite easily at hand the notes of the moderation meetings that have been made, and also any preliminary comments that the evaluators may have made, because these are actually documents that are inevitably requested quite early on by a claimant. They will want to see those moderation notes in particular. And having that information available will aid discussions with your legal advisors. Just finally, coming to the end here, I wanted to say a word about privilege, because this is a critical concept to be aware of. So again, once proceedings are issued and you reach the stage of litigation known as disclosure, that's when the parties may well have to disclose all the relevant documents to the other side. If, however, a document is considered to be subject to privilege, then it does not have to be disclosed to the other side. So it's very important here to know which documents are and are not privileged. Legal advice privilege applies to confidential communications between a lawyer and their client, where those communications are for the dominant purpose of seeking and receiving legal advice in a relevant legal context. The other most type of common privilege is litigation privilege. This applies to protect confidential communications between a lawyer and a third party, or alternatively between a client and a third party, which have been created for the dominant purpose of obtaining information or advice in connection with litigation, which is either existing or is reasonably contemplated. Privilege can be lost, however, if documents are shared too widely and beyond those people who can properly be categorised as a client, or if the confidentiality in the documents are compromised. So it's always important at the outset of any dispute to think carefully about who the client should be, as these will usually be the individuals that are authorised to be seeking and receiving legal advice. If in doubt, you need to consider whether that person does have a legitimate interest in the legal advice process, and try to keep the group of those individuals as small as possible, and so as to ensure that you don't actually circulate any documents beyond that group where you might then lose legal advice privilege. Just a word of caution if consultants are involved, because I know they often are when it comes to the public sector. So you would need to check whether that consultant is actually authorised under the terms of their retainer to give and seek legal advice. And then if their role does actually legitimately involve them being involved in that legal advice process. Essentially, privilege is a very complicated area. I would advise getting lawyers involved quite early on to advise on how to maintain that privilege if a dispute arises, and essentially to minimise all written communications as much as you can. Thank you very much.
Thank you, Suzanne.